The lawyer for the alleged gunman in the Senzo Meyiwa murder trial has argued that the evidence from ballistics experts are inconsistent. Olebile Sereo has been under cross-examination over the findings on the work done by the state's ballistics expert, Mangena. 5 men are on trial for the 2014 murder of the soccer star. Newzroom Afrika's Mnisi reports.
At the heart of Lieutenant Colonel Olebile Sereo's evidence is that he agreed with the state's ballistic expert, Mangena, that the firearm allegedly recovered from accused No.3 Mthobisi Mncube matched the bullet that was found at the crime scene after the shooting that left Meyiwa dead. But the defense is arguing that Sereo could not have reached a proper conclusion due to what they say are differences in the tested bullets.
His confirmation of Mr. Mangena's work to have been positive could not have been proper because they were working on exhibits which did not have similar characteristics. That is what I'm trying to say.
I have already explained that the ballistics is not based on the fact that the marks which are visible on even bullets fired from the same firearm, those marks are not microscopically identical. They are similar. They are similar to a certain degree. So what you see on test number 1 is not a photocopy of the surface of test bullet number 5 or number 6. The degree of similarity among the tests will show that they have a common origin, but it does not mean that they are microscopically identical.
The state contends that Mangena's evidence is that he chose the bullet for purposes of the chart because there was better transferability on them and not because they were bent. At the same time, Mncube's lawyer also challenged the handling of the firearm when it was booked out by Mangena for testing. He argues that he did not follow procedure, but Sereo says there are circumstances that warrant a deviation from standard ballistics procedure, and he made an example of a case where the defense's own ballistic expert, Dave Peterse, was involved.
We do receive firearms that come to the forensic science laboratory for testing for the purpose of IDs. And when they come, they are not sealed. And then I can make example with another case again.
Yes, proceed.
Which was examined by Mr. Dave Peterse, who was in this court.
Proceed.
Steel trommels of containing firearms were transported from Marikana. In the Marikana case, they were conveyed to the lab in trommels and they were not sealed individually.
Yes.
So in that case, we didn't have the seals that reference is made to. That is why I say there may be other situations that I might not be able to remember.
But Mnisi wanted to know if procedure was followed in this instance.
In the circumstances which have just been sketched now, yourself being a member of the Forensic Science Laboratory of South Africa, was procedure followed?
My answer cannot be detached completely from what happened at that. The generic procedure in the SAPS was followed. Why I'm saying so is because the firearm, according to information that has just been supplied to me now, Mangena did not just go to the station, took the firearm and left with it. He booked it at the police station, which means that he completed the SAP 13 or the exhibit register at that particular station.
I can tell you that is not in dispute.
So I was just explaining regarding the generic police procedure, not the forensic procedure, the generic police the procedure actually that empowers a police officer to do certain things. So in terms of the police protocol, he is entitled, he is able to book it out. However, I'm going to admit that there was a slight deviation from the normal course with respect to the ordinary forensic science procedure. That is why I wanted to refer to Mangena's affidavit.
Sereo is part of the 4 people that agreed with Mangena's findings. He wrapped up his testimony, paving a way for a new witness to take the stand. For Newzroom Afrika on Channel 405, I'm Mnisi.